Ladies and gentlemen, a very good afternoon to everyone. I am Petine Nguna. I'm a director in the firm Cliff Decker Hoffmeyer Inc., and I am pleased to welcome everyone. Just to say a few words in welcoming our great panelists, the bank, Nedbank, as well as every delegate who's graced us with your presence. We are very delighted as a firm to be hosting the Women and Juniors in Law and Banking Business Rescue Seminar today. It is a great pleasure, I must say, to catch up with familiar faces and to also meet some new people I personally don't know. A very warm welcome to everyone. First and foremost, I would like to extend a very warm welcome to some of our distinguished guests. We are honored today to have with us Zanele Mgandi, the GC of Nedbank, whom I will hand over the proceedings to shortly. Nedbank, as some of you would know, is the brainchild behind this very initiative and a series of events that aim to upskill a more diverse group of practitioners for a betterment of the legal sector. We sincerely thank Nedbank for allowing CDH the opportunity to be part of this very, very important and wide-ranging initiative. We are also pleased to welcome Deline Chetty, Head of Legal, Corporate and Investment Banking, who will be moderating the session. Also not forgetting the invaluable input and role played by Welegazi, who is the Group Head Litigation, Dispute Resolution and Employment Law, and also steering this ship. Your combined presence, I believe I speak for the firm at large, your combined presence today truly enriches the session, and we are most grateful for your time, support, and faith in our ability to partner with the bank in this initiative. From CDH, I am delighted to welcome Nastasia Harduth, who's joined us recently as the Head of Business Rescue, Restructuring and Insolvency, together with the Director in our Dispute Resolution Department, Mr. Vincent Manku, who are together participating in this panel. We also warmly welcome Lauren Davids and as well as her other colleagues from ENS. She particularly will be part of the session. Thank you, and thank you to ENS who did chair this initiative before CDH came on board. Not forgetting advocates Karusha Pillay from Duma Nokwe as well as Shomani Matiba from Maisels Group. A very warm welcome. Last year, the African Union released the following missive, Aspiration 6 of Agenda 2063. This envisions an Africa whose development is people-driven, especially relying on the potential of its women and youth. Promoting gender and youth mainstreaming on the continent is essential for an inclusive Africa, where the voices and concerns of 75% of the population that constitutes of women and youth are not only heard, they are also acknowledged, welcomed, and also considered in decision-making tables. The inclusion of women and youth has been, and I must say, continues to be an important part of what the AU, as well as already included in its constitution, seek to achieve. This is a fundamental human right and is quite integral to the accelerated growth of the continent as well as social development in Africa at large. The legal sector in the continent faces similar challenges apart from what has already been identified as challenges plaguing the profession. This is not just limited to South Africa, it's continent-wide. The Cyrus R. Vance for International Justice recently released its report on the Advancement of Women in the Workplace 2024, which clearly demonstrates that underrepresentation of women is still a big problem, not just in the South African legal industry, but across the continent. This problem obviously has a lot of facets, and the genesis of it is quite incapable of clear identification, as the report notes. While there is no single cause, something which we constantly continue to acknowledge, several key factors have been highlighted in the report. Some of these include a lack of work-life balance, lack of mentorship, and a gender pay gap. The survey results also touched on briefing patterns. The results show that 69% of respondents who participated in that survey agree that males and females unfortunately continue to not be afforded equal opportunity of access, not just into the legal profession, but into specific areas of law. Close to 73% of women actually said that there continues to be disproportionate patterns in briefing. Not only are they not getting access to certain type of work, they're actually not getting briefed at all. About 89% believe that female advocates continue to not be briefed as much as male advocates. These obviously very stark and contrasting figures point to a need for initiatives such as the Women in Law and Banking. According to the Young Lawyers Report, which was issued by the International Bar Association, about 93% of participants who took part in that survey identified that a lack of mentorship, a lot of enablement of access to certain areas of law is one of the reasons why their careers just never flourish. They continue to complain about not just not getting briefs, but they are actually not exposed to certain types of work, which again points to why there is a need to partner with banks such as Nedbank in these type of initiatives. As I end my welcome, I want to reiterate that the experiences of females, as well as junior practitioners, as well as their interest, will undoubtedly not just shape the future of the legal profession at large, but will also determine what we look like tomorrow. We've recently celebrated 100 years, and we would like to see 1,000 more years of women and juniors participating, not just in the traditional fields of law, but into what we call the niche areas of law, such as banking. With that being said, I'd like to welcome Zanele to the podium.
Good afternoon, everyone, or is it good evening? Before we start, I would like to actually start by acknowledging and honoring the recently late Judge Yvonne Mokgoro, who is one of the preeminent women in the legal field, as well as in the judiciary. I think this function and this room is hopefully something that she would look at and think that she has contributed to women being in the forefront of the legal field. Pateni, I think you give us way too much credit when you say that this is the brainchild of Nedbank. 2 years ago, we were at a function with Tracy from ENS, and it just happened that we were talking about what we want to do as women in the legal space. 3 years ago, I became Chief Legal Counsel at Nedbank. Delene became Head of Legal for CIB. Wolegazi became Head of Litigation for Nedbank Group Legal. And I think it just happened that we were, all three of us, aligned in terms of the fact that we have been in the legal field, and especially Delene and I, who have been in banking for over, combined over 20 years. And in that time, not only have we not seen a lot of women growing in the legal space, in the banking industry, but we have not seen the briefing of female counsel, female advocates in the banking space. And I mean, we both headed legal departments. We were both in charge of making sure of briefs of counsel in that space. And in that time, I don't want to pretend as if we did not have any power to influence it, but we did not have a lot of power to influence who got briefed. So when we gained a little bit of that power, we decided we are going to try to use it to make sure that we get involved in initiatives to ensure that there are a lot more women who get briefs from banks. And thus, this initiative started. This initiative started as a way of getting women at the bar, familiarized with what we in the banks do and what we need from them. And that was in the hope that that would inspire and get them to see the fact that we do actually want to try and get more women doing banking legal work. And the initiative has grown from just ENS and Nedbank to involve other law firms. And as you will see from the panel, it's not just ENS and Cliff Decker who are on the panel and who speak on any of the subjects, but we're trying to involve other law firms. And we're also trying to involve other banks. And we are hoping that in the future, we will have other banks join us, and the initiative will grow into an actual push towards getting more women. And I'm not saying that other banks actually are not involved in that. There's a lot of initiative. There's an initiative of diversity in banks that is run with other banks as well as other private corporations. And this initiative is just one of the initiatives that are aimed at making sure that there is diversity in the legal field. So while this is a small initiative, this is just starting. I mean, we started 2 years ago, and we are just starting to fill a room. So this is small by all comparisons, but I think anything that you can do to start the right thing, to do the right thing, is good enough. And we hope that with your support, we'll be able to grow with this initiative, and with your support and understanding that no one function, no one panel discussion is going to ensure that everyone in this room gets a brief. But I think anyone who has attended these sessions from the time we started will tell you that there are people who have gotten briefs because of this initiative. So we hope that the panel discussion today will be interesting enough, and that you will stay behind after the panel discussions for the networking sessions, that we'll all get to meet each other and have discussions on what more can we do. Is there anything else we are missing that we are not seeing? And we hope that you also see this initiative and what we're doing from our point of view as well. On that note, thank you very much, Delene. Over to you.
Thank you. Thank you, Zanele. I'm not sure, can everyone hear me? Thank you very much for joining us today. And the reason we have chosen this business rescue topic is because even though it is so topical in the press and there is so much of work that seems to come out, as the client, Nedbank, we only see the same players all the time. And the idea is for today, for us to do a brief introduction to business rescue, what it might mean for us as a bank, as counsel, as attorneys. And, you know, to the extent that other sessions might be needed, we are open to that. But let's just kick off with you, Karusha. Can you please give us an introduction of and an overview of business rescue? But in particular, we know there's business rescue, we know there's liquidation. What are the principal differences there?
Okay, good evening, everybody. And thank you for joining us this evening. Delene, thank you for that question. I think let's start by the Companies Act, or the new Companies Act, so which commenced on the 1st of May 2011. Importantly, one of the objectives of the Companies Act is to provide for the efficient rescue and recovery of companies that are financially distressed. And if we look at Chapter 6 of the Companies Act, it provides the legislative framework governing the business rescue procedure. And business rescue has as its purpose to restructure a company and restore it to profitability. Now, to answer Delene's question, the difference between business rescue and liquidation is that business rescue is to save a company, put very simply, whereas with liquidation, we see the demise of a company. So the purposes and the aim of both business rescue and liquidation are completely different. I think importantly for us to consider, with liquidations, there is a concursus, that is formed, which is not the case in business rescue. Now, I think it's important for us also to look at how does business rescue work. And so business rescue has effectively three components. The first component is that there is a moratorium which automatically arises, and it provides much needed breathing space for a company because the rights of creditors are temporarily, to enforce their claims, is temporarily halted whilst the business rescue procedure unfolds. The second component of business rescue is that a business rescue practitioner who's qualified in the field of business rescue is appointed to temporarily supervise and take over the administration of the business. The third component is that while that happens and while the moratorium is in place, the business rescue practitioner develops a business rescue plan which restructures the business of the company, including its assets, its liabilities, and its affairs, so that it can be restored to profitability and it can continue to function. In the case of liquidation, a liquidation marks the complete end of the company. If we look also at the difference between the two, importantly, with business rescue, it is a situation where all of the stakeholders that are involved are fairly dealt with, in the sense that with the moratorium, the creditors temporarily cannot enforce their claims. So it gives the company the breathing space that I spoke of. But at the end of the process, or at the end when the plan is developed, the creditors then have the opportunity to vote on the plan. So it is important because there is that fairness and the balance, whereas in the case of liquidations, it is simply the end of the company, full stop. It is something which is very pro-creditor, whereas if we look at business rescue, it is said to have been a shift from being pro-creditor to a pro-debtor situation. I think very important in the South African context is that in the case of liquidations, marking the end of the company, the inevitability is that there's a loss of jobs. Whereas in the case of business rescue, it is often the case that you might find that there are losses of jobs, but there is a great opportunity for jobs to be protected. Now, the implications of that in the South African context is that it avoids the socio-economic consequences caused by job losses. That in turn impacts the development economically of South Africa. It also instills investor confidence and makes foreign investors more willing to do business in South Africa, considering the fact that we have a good framework for the efficient rescue of companies that can be rescued.
Thank you, Karusha. That was a very comprehensive overview. Appreciate that. Nastasha, let's go to you. I want to talk practicalities now. You know, we have established why business rescue is important, certainly as opposed to liquidation, but let's talk practicalities. How does it happen?
Okay.
Deline, the long and the short of it is in one of two ways. Either the board can resolve to place the company voluntarily into business rescue, or an affected person, and Shimani is going to deal with this, is going to make an application to court.
Would I be an affected person as the bank?
Depends, are you creditor?
Oh, okay.
Not all banks are creditors. We'll leave it at that. So, but I think if you're going to be talking practicalities, there's a few things that we need to be touching on. So, you are going to have to deal with two aspects before you place a company, either through the court system in business rescue or the board resolves to place the company into rescue. And the two criteria is really this. Is the company financially distressed? And is there a reasonable prospect of rescuing the company? Now, financial distress is supposed to be a forward-looking test. You are, as a board or as affected person, you should be able to either convince yourself, if you're a director, or convince the court, if you are the applicant, that this company will, in the foreseeable 6 months, either be unable to pay its debts or become insolvent. So let's just pause on what insolvent means. The court has had cause to consider what insolvent under the New Companies Act means, and it isn't where your liabilities exceed your assets. The court in Boschpoort Ondernemings, in fact the SCA, said that insolvent in the context of the New Companies Act actually means commercial insolvency. So in other words, you cannot pay your debts as and when they fall due. That is both really the test for liquidation, and it's the test for business rescue. Now, there's a few things that the board needs to consider before they pass the resolution. Because if you pass the resolution, if a company is not yet commercially insolvent, or it's not going to become commercially insolvent in the foreseeing 6 months, or the ensuing 6 months, then if an affected person, a creditor, shareholder, employer, or trade union, comes along and tries to set aside the resolution, and the company wasn't yet commercially insolvent, the directors can be held liable for the costs of that application. That you'll find under Section 130, sub 5. On the other hand, if you do not place a company in business rescue, in circumstances where it is financially distressed, the directors can be held personally liable for the debts of the company because they're essentially trading recklessly. That you'll find in Section 129, sub 7. So where the directors find themselves in a voluntary business rescue is really between a rock and a hard place, because they can either be held liable if they pull the trigger too soon, or they can be held liable if they don't pull the trigger at all. And I think here an important distinction needs to be made. There's a difference between financial constraint and financial distress. And I think you will agree as a bank that you don't want your creditors to just, or your debtors to just jump into business rescue, because business rescue can be a value destructive process if it's entered into prematurely. But it can preserve value if it's entered into at the right time for the reasons which Karusha has just explained to us. So when a company is financially constrained, it becomes incumbent on the board to start monitoring for financial distress, because they don't want to be liable either way. And when you monitor financial distress, you have to be careful and vigilant not to confuse the symptoms with the causes. A symptom is a Section 345 letter that lands on the company's doorstep, right? Creditor complaining that you're not paying me, I'm going to deem you to be insolvent if you don't pay me within 3 weeks. That's a symptom. The cause can be poor cash flow management. The cause can be too aggressive expansion. The cause will, more often than not, and 99% of the time, arise for internal reasons. And you can probably lay it at the door of management. Right? So the very management that is potentially the cause of the financial distress or constraint will also be are saddled with the responsibility of placing the company into business rescue. So it's a balancing act. But yeah, that's how you place a company. One of the ways that you place a company in business rescue is through a board resolution.
Board resolution. So, on the assumption that Nedbank is an affected person because we are a creditor, now we obviously can't pass the resolution. What happens next? I mean, let's go to you, Shamani, and I would like you to maybe ask you about a matter that you have been involved in, as I well know, something we've seen in the media quite a lot, and that would be the Mango Airlines matter. If you could give us some insights and a little bit of how you would go about doing a court application.
Yeah, so my colleagues have mentioned that you can get into business rescue in two ways. The one is the resolution, and the other one is an application in terms of Section 131 of the Companies Act. Now, that application is made by affected parties, and affected parties are defined in Section 128 of the Constitution, of the Companies Act. You see what kind of work I do. I think this is the Constitution. And those include creditors, shareholders, and so on. Now, the caveat there is that you can only bring that application if a resolution has not been taken by the directors. And so it's for that reason that a director cannot bring a Section 131 application. And so for Nedbank as a creditor, Nedbank will have to bring an application in terms of 131. In that application, you'd have to prove the same things that a director would need to prove in a resolution. In other words, financial distress, as well as a reasonable prospect of rescuing the company. Now, mention was made of liquidations. It's another caveat of 131. You cannot. So liquidations generally mean that a company has died. What becomes interesting then is what you find if you read Section 131 further, is that one can actually bring this application once the liquidation proceedings have commenced. It's not a new issue, but it's certainly a very interesting issue, because logically you would think that because a company has died, or it no longer proceeds to trade and it's entered the winding up process, you can't breathe air into it, and so you can't take a business rescue application and resuscitate it. But if you read 131, 6 and 7 and the wording thereof, you realize that it's very possible. In fact, maybe let me just read that section just for context, or parts of it. 131 6 says, if liquidation proceedings have already been commenced by or against the company at the time an application is made in terms of subsection 1, which is the main clause for the application will suspend those liquidation proceedings. And so from that section and the wording of it, you realize that it is in fact possible to bring a business rescue application during liquidation proceedings. Now, I mention this because it adds a further requirement. You can imagine that directors would realize that they haven't placed the company in business rescue. Nedbank comes and places the company in business rescue, or in liquidation, or any other creditor places in liquidation. A shareholder would want to come and prevent the liquidation process, and therefore abuse the entire process. And so the requirement that has been added in the Richter case is that you must demonstrate a possibility to resuscitate this company beyond. Now, this becomes difficult depending on the liquidation proceedings and how far they've gone. The wording that the Richter case uses is a radical improvement. in the business such that it can trade again or to profitable margins. And so what you have is that you need to prove the requirements. Firstly, that you have to prove financial distress, a reasonable prospect of success, and then you have to prove this further requirement, which is, in my mind, incredibly difficult if a liquidation order has been taken. And so, under those circumstances, it is not as simple as it seems to place a company in business rescue generally through 131, and it becomes even more difficult if a company has been placed in liquidation, because you have to prove pretty much the impossible if a liquidation order has already been taken, because the court has already found that this company cannot be saved in that sense.
So I suppose then that it would... Sorry, go ahead, Nastasha.
I just want to just, for the audience's sake, bring this real-life example to their attention. A company that has gone into liquidation, at least provisional liquidation, and then into business rescue is the post office. Now, I want to ask you, if the post office can do a pivot, not so difficult. You just have to draft your papers well.
Right. And you're quite right. I mean, Mango is a similar situation. What we encountered in Mango is that the shareholder in Mango is SAA, and the shareholder in SAA is the minister. And Nastasha will speak about how there was an intersection between 129 and 131 in that matter. But in that matter, there was already a liquidation application by a creditor. Mm-hmm. They were well advised.
Was not the shareholder or government? Or
No, it was just another creditor who had thought this company cannot be saved, and through the work of worksmans and others, a resolution was passed by the board, but it needed approval from the minister, and so it took quite some time before it could be filed, and that was the debate whether it's still valid or not. But the other issue was whether the company can be placed in business rescue via a Section 131 application, which was brought by the employees in circumstances where liquidation application had already been brought. The creditor was well advised to withdraw that application, but in circumstances such as SAA and Mango, where the state is involved, it's very possible to have that radical improvement in the company. And so Nastasha is quite right. It depends on who you have and how you draft your papers.
And who has funding, I guess.
Yes,
Or
quite
not.
right.
Or not. We're still waiting to see money from the government for the post office. So, or not. What I do want to say, and just to give some context for everybody here, is in the Mango matter. Mango's board passed a resolution in April, April 2021, to place it into business rescue. It had to seek consent or ratification from its executive authority, which was the Minister of Public Enterprises. That took 3 months. And in that 3 months, after the resolution had been taken, in that 3 months, a liquidation application was brought, and Mango tried to file their resolution with the CIPC, remembering that your resolution only becomes effective once you do file it with the CIPC. But the CIPC said, no, you're out of time. While Mango was having its little tiff with the CIPC about filing the resolution, the Mango Pilots Association brought the 131 application. And the court said there that, also, just for context sake, while we were having this little fight with the CIPC, they obviously acknowledged that they got the thing, because they were like, we're not going to register it. So there's a distinction between the Old Companies Act and the New Companies Act, where the Old Companies Act talk about registration, where you had to register things, whereas in the New Companies Act, it talks about filing. And filing, if you just read through all the parts of the Act, is really just delivery, right? So it was filed. They said they got it. They just said they're not going to register it. And so the whole fight was whether or not the Section 131 application could be brought in circumstances where it was filed or not, and what is reasonable time for filing. And that is a very circumstance-specific question, because here they were in the hands of the minister, and government, not always as fast as you'd like them to be, took 3 months to consent and say, we ratify your resolution. Resolution was taken, we're happy with the resolution, now you can go and file it. So the court said that that resolution was filed, that government is backing this whole thing, so there is a pivot, or there's room for a pivot, and Mango Pilots Association, sorry, but you're out of time, because it's not a matter of when you file it, it's whether it's reasonable time in which you file it.
So that is quite a complex set of legal principles to get your mind around, especially when you are the principal drafter of these papers, and such an interesting insight. But I'm going to leave you both for a moment, and let's talk about, once you have a business rescue application and the court has ordered, Karusha mentioned a moratorium. Vincent, can you help us understand what that moratorium means for the enforcement of a creditor's rights, particularly in regards to security? So as a bank, we would typically take a debtor's book, we would take a general notarial bond, a mortgage bond, there'd be other forms of security. As a bank, how does that affect us?
Thank you very much, Darlene. I think we can all accept that one of the stated advantages of business rescue, as Karishka correctly identified, is the general moratorium on legal proceedings. But it goes further than that. There's a couple of things that we need to talk about. One is that legal proceedings also includes enforcement action. So what that means is you can then not enforce a court order, execute a court order, for example, against the company business rescue. But there's also an important qualification, because it talks about that general moratorium will only apply if a company, in respect of property that belongs to the company. There are two things there. So that property has to belong to the company. That's one. Two, it talks about the fact that, or that property has to be in lawful possession of the company. So what does that mean? Assume you're a bank. Let's assume you've got a lease,
Plant and equipment.
There's a breach, you cancel. What do you do if that company then goes into business rescue? And as I was preparing for this, I needed to remember that I'm not speaking to clients, so I'm speaking to counsel. So what do you look out for as counsel in those instances? Presumably the bank will come to you on a couple of things. One, they will want to know whether that cancellation constituted enforcement action. They will want to know that. The second thing I think that's important as counsel to look out for in those circumstances would be whether that property, because remember the moratorium only kicks in if the property is in lawful possession of the company. So the bank would probably want to know whether that equipment, whatever it is, or if it's a lease, whatever it is, whether it's in lawful possession of the company. Take the lease, for example. If that lease was cancelled, at the time that the company goes into business rescue, are they in lawful possession of the property? Because as a landlord, for example, we're looking at a couple of things. One, you would want your arrears, so you'd want to recover that. Two, you'd want to eject them as soon as possible. And also, at the time that you haven't ejected them, there's a rental that's accruing, you'd want to recover that. So those, I think, there are two things that, as counsel, a bank would then come for you to advise. On the first one, so this was a bit controversial, I think, around 2016 and with the first rent cases and stuff. The position seems to be that cancellation would not constitute enforcement action. The second thing would be that if so, then the company would not be in lawful possession of the property. So in those facts, you can then, as a bank, for example, eject that company even though it's in BR.
So you are making a very important point here, because evictions are normally done via the court. Are you then saying that if a landlord cancels an order, cancels a lease because a company is in business rescue, they can actually evict their tenant, and that eviction would or would not be enforcement action?
Yeah, so if that cancel, so let's separate. Let's deal with the cancellation, and then let's deal with whether that property is in lawful possession of the company.
Okay.
First, that cancellation would not constitute enforcement action, because enforcement action goes to, for example, executing on a court order. Let's assume you have a money judgment, you want to go and attach assets, you send the sheriff. That would be enforcement action. So that you can't do. But the act of cancellation itself is not enforcement action.
Because it's a bilateral act.
Yes, that's
Understand.
correct. Secondly, once that agreement is cancelled, the company is no longer in lawful possession. So therefore, you can evict and you will not be hit by the moratorium. That's quite important to make that distinction.
That is very, very important, something I didn't know. And when you say enforcement action, what I'm understanding from that is it's enforcement action via judicial intervention. So that would include court orders, arbitrations?
Yes.
Same thing as enforcement action?
Correct.
Okay.
There's a case to the effect that arbitration also includes enforcement action. So so for example, if the company goes into business rescue, you have pending arbitration proceedings. Those would then be hit by the moratorium. Of course, I must mention that yes, the general moratorium. However, there are exceptions. You can get a written consent of the BRP. The court can give you leave, but you obviously have to make out a case for it. Issues around statutory bodies, when they exercise their duties, those would not be hit by a moratorium, things like criminal proceedings and the like.
And all of this guidance is available in the framework, the Act, and the case law, I imagine, because you sound extremely knowledgeable. But for counsel that haven't had the opportunity to deal with it, where would they find this kind of learnings?
Look, to be fair, the section itself, the general moratorium, it's a very short, I think it's only 2 or 3 subsections. So a lot of what has developed from the section has been from case law, First Rand, the Mare case, the one on arbitration, Chetty, Hart, I think. So a lot of the jurisprudence that has come out of 133 has been from case law.
Right. Thank you. I'm going to park for a second, and I'm going to go to Lauren. Lauren, are there instances where you can, or I can, as a bank representative, enforce a piece of security where it's not considered enforcement action? I mean, are there any pieces of security that exist in that way?
Yes, thank you, Deline. I think the most common example in our industry and in the business rescue space particularly is where there's a cession of book debts, because we know that when a cession is executed, the rights, title, and interest to those book debts are immediately transferred or made over to the creditor. Such that, and we know that all of the modern sessions also deal with future debts. So when those future debts arise, there are no further obligations by any of the parties. Those debts are effectively transferred to the creditor. And so what that means in the business rescue space is that a business rescue practitioner cannot deal with debts that have been ceded to a bank and in any which way. He does need the consent of the creditor to do so. And I thought that maybe I could give a quick example of how this played out in one of our matters at ENS. So there was a company, a mining company. It went into business rescue. Well, our client was not advised that the company went into business rescue, but they managed to pick up in the press that there were business rescue practitioners for this company, and the practitioners said that they had identified non-performing assets and that they were in the process of actually collecting book debts, and that they were going to sell these assets and use the proceeds of these book debts to run the business rescue process. So as soon as our client saw this in the press, they came to us for assistance, and they said, please, we have security over these assets. We have a GNB and we have a session of book dates. Please address correspondence to the business rescue practitioners, which we did. We said, firstly, the company has gone into business rescue, it has defaulted on its loan agreement, and we are choosing to enforce our cession of debtors. The issue in relation to the GNB is a little bit different, and Vincent will touch on that. But in relation to the cession of debtors, we said we are now enforcing, or our client is enforcing its rights in terms of the cession of book debts. And what that means is we are requesting a number of documents. We want to know, for example, who your debtors are, when are they required to make payment, how much do they owe the company, because we knew that we had to urgently let the debtors know that they were now to be paying our client directly, because we know that in a session, if the company's debtor pays the company without knowing that in fact they're supposed to be paying the creditor directly, they've met their obligation. Then there's nothing you can do about that. So, as I said, we wrote to the practitioner. We said we want a list of your creditors. We want to know how we can get hold of them, and please undertake that any debts that you have now received from debtors will be paid over to our client and put into our client's nominated account. So, as happens, the business rescue practitioners completely ignored us. And a few days later, we were then required to institute urgent proceedings. And in terms of those proceedings, we, one, requested that our GNB be perfected, and the principles, as I said, will be dealt with by Vincent. We requested that the practitioners or the company represented by the practitioners be compelled to comply with the provisions of the cession agreement by, inter alia, handing over this very important information that we need in order to protect our clients' interests. And we also requested that the company, as represented by the practitioners, be interdicted and restrained from dealing with those assets without our client's consent, as per Section 134 of the Companies Act, which I will touch on briefly a little bit later.
Actually, go ahead and touch on it now, because
do you just want me to? Yes, I think it actually
Sorry.
makes sense if I quickly just go to it. So Section 134 of the Companies Act is quite an important section, because I think it definitely takes into account the interests of all stakeholders, and what it deals with is the protection of property interests. And in 1341, firstly, before I go to secured creditors specifically, in 1341, that section deals with the circumstances in which companies can dispose of their assets. There are three ways. The one is in the ordinary course of business, and this would be obvious in circumstances where the company is a retailer and it is actually selling its assets. Its business, its operation is to sell its assets. Then second, the other way in which it can dispose of its assets is in a bona fide transaction at arm's length for fair value, where the business rescue practitioner has agreed to such disposal beforehand in writing. And I think that is obviously an attempt to prevent simulated transactions, a way to get assets out of the company. And so then, and the last circumstances in which the company can dispose of its assets is where it is contemplated and implemented in terms of an adopted business rescue plan. And that is obviously in circumstances where the plan was published, creditors had an opportunity to look at that plan, how the assets will be disposed of, the value of the assets, etc. So those are the three circumstances in which the property of the company can be disposed, and it is effectively a way to protect third-party or all affected persons, essentially. Then specifically, when we go to secured creditors, we know that business rescue practitioners cannot dispose of assets over which there is security or a title interest unless they get the consent of the person with that security or title interest. And there is another proviso to that. If that asset can be sold for an amount that exceeds the debt due to the creditor, the practitioner can proceed to sell it, but we need to be aware that that practitioner also needs to comply with 1343 3B, which says that when those proceeds are received, it needs to be promptly be paid over to that person with a security interest. Alternatively, the business rescue practitioner must provide security for that debt or for that asset, but to the reasonable satisfaction of that security holder.
Okay, so
Sorry, that was a mouthful.
But that leads us very nicely into general notarial bonds. Very, very popular form of security over equipment in particular. We finance the equipment. But if the creditor, the bank, misses the boat and let's say the resolution is passed before the bond is perfected, Vincent, help us understand. What then?
Yeah, maybe let me start with how it normally works if the company has not yet gone into business rescue, then I can contrast that. Normally, a GNB, we know it's not real security yet. You need to perfect it before you can enforce it. And this becomes important in the context of insolvency, business rescue, and the like. And the reason that's important is because if you have an unperfected GNB, you're not going to be a secured creditor. I think you only rank ahead of concurrent creditors. So it's quite important to perfect. What does perfection mean? Two things. Natasha will give a brief to Shomani, draft papers, go to court, get that order. But getting that order does not mean that GNB has been perfected. You actually need to take possession. So that's quite important, because if you don't take possession, you haven't perfected your GNB. Once you've taken possession, in most instances, you funded, furniture stores or retail business. Sometimes you want it to continue operating. What you then need to do is you may conclude some sort of an agency agreement with that person to continue operating, or whoever. You can put a security in place or however arrangements you want to continue with. But what's important is in the context of perfecting is you need to take possession. If you have not taken possession, you have not perfected. So that's normally how it works without BR. In most instances, before a Section 129 that they've mentioned, or an application to court to place the company in business rescue, more often than not, you as a creditor, as a bank, as soon as you learn of the financial distress, right, not financial constraint, as Tasha said, as soon as you learn that there's financial distress, or there's a risk of liquidation perhaps, or the landlord is about to perfect the hypothec, right? It's incumbent on you to then, as a bank, to go and perfect that GNB. Because as you said, if you don't, then you're only going to rank with preference ahead of concurrent creditors. However, during business rescue, you can perfect, but remember, there are two things. You will then be hit by the moratorium that we mentioned earlier, so you'll need the consent of the BRP. Secondly, the BRP will, if you haven't perfected, the BRP might be reluctant to give you that consent. So you can sort of think about issues like PCF to say, well, do you then use those assets in exchange for PCF in allowing you to perfect? So those are some of the options that you can then have as a creditor.
Okay, so that's quite a terrifying prospect, I must tell you, because what you are saying then is if a GNB is not perfected and you do not get consent, then potentially a business rescue practitioner can sell those assets. And then what happens to your protection of your property rights? Are you not considered to be are we not as Nedbank considered to be a secured creditor?
Yes, so if it's an SNB, for example, you will be fine, a special notarial bond. But in this instance, because it's a general notarial bond, you only rank ahead of, and it's just important because a general notarial bond, remember, would have been over all of the debtor's assets. So it's not specified assets. So all it means is you'll then rank above concurrent creditors, which is why perfection of GNBs in particular is so important in the context of liquidation, insolvencies, and the like. So because it will then elevate your status as a creditor, as a bank in this example.
ironic then that there are so few practitioners in the market who actually do perfection work. And I think it's a good place to expand one's knowledge, because as I understand it, it's always an urgent application. It's complex, it's difficult. If you're taking possession over various sites, it becomes logistically very difficult. Thank you so much. Just before we go to comments or questions, are there any last comments from our panel members before we go to questions?
I have one.
Go ahead, Natasha.
I think that there is a topic that we need to chat about that we haven't yet, and that is suspension or cancellation. And I think this is important. A business rescue practitioner has the right to suspend an obligation of the company under an agreement that was concluded prior to the company entering into business rescue. The business rescue practitioner can also apply to court, the Act says on an urgent basis, to have such an obligation cancelled. There's a common misperception that a business rescue practitioner can somehow also cancel the rights of affected persons, including their contractual rights, or even just cancel the contract. It's not true. Your contractual rights remain extant while the company is in business rescue. That's borne out in cases like the Kathira court case, BP. There's a lot of them. And so I think my closing remark would be that even though business rescue seems like this crazy, daunting animal, it's really business for the creditor. It's really business as usual in unusual circumstances. And so that would entitle the creditor to, for instance, go and enforce the cession, because the rights are no longer that of the company, it's that of the creditor. And so that is the one thing that I would want to leave people just also with.
So that we're not too terrified. Understand. I think that this is probably a good time to go to questions, if there are any. I'm not sure if there is a mic that might be circulating. I see there's a question in the front, Sanele. And, sorry, just if you could wait for the mic. Thank you.
It's less a question than a request. I mean, you already started with pointing out the perfection of GNBs as a practice area. And I think the panel can assist in that, to point out the different practice areas within the business rescue process. In other words, where counsel will be required, for example, to prepare an application, to go argue an application. And there's different, I would imagine there's different interlocutory applications in the process that do not just involve the attorneys or the business rescue practitioners. So I think it would be helpful to point out, if that is possible at all, any of those practice areas that would point people in the right direction.
That is a great question, and go ahead.
It's not necessarily a practice area, but something that has come up many times in my practice with business rescue matters is the rights that creditors have in the legal process. So Section 145 says that where there are legal proceedings, creditors, affected persons have a right to participate, and it also says that they must be given notice of those proceedings. Now, it becomes tricky where a business rescue plan has already been approved. In other words, it's been voted by the creditors. The creditor needs to participate in the process. And the courts have said that where a business rescue plan has been approved, all the creditors must be cited. And the logic in that is that, well, you can't say in participation a creditor has executed its right by merely just giving it notice. Giving notice doesn't mean that the sheriff will serve the application on the person, and it doesn't mean that the creditor binds themselves to the order that the court will grant. And obviously it links up to the general rule around joined and non-joiners, that you have a direct and substantial interest. You voted on a plan, you say, I'm prepared to take so much, and your rights will be affected. And what you often find is that someone who's disgruntled would want to set aside the business rescue plan but does not cite all the other creditors. And so the point I'm making is that often in these matters you find that there are a lot of creditors who needs representation. It's obviously not as intense as it would be if the creditor itself brings the application, but you would be involved, and in many instances junior counsel participate in those proceedings to protect the interest of the creditor in that sense.
So far we've identified, thank you very much, that is so valuable. We've identified representation of creditors at meetings, at plans. Interdicts, thank you for that, Lauren. We've also identified perfections. I'd like to go to you, Lauren, I see you nodding, and perhaps you, Nastasha, the practicing attorneys, and Vincent in the room, who would have sight on the kinds of things that counsel could get a brief on.
We'll go?
Go ahead,
I think-
unless Lauren or...
So even though business rescue is not monitored by the court as you would have in other jurisdictions, the courts are definitely involved. So as an affected person, you can bring an application to set aside the resolution. As an affected person, you can also bring an application to set aside the appointment of the business rescue practitioner. You can go to court to enforce your rights, provided that you have the necessary consent. Yeah, those are the three that jumps out at me at the moment. I don't know if Vincent and Lauren have others.
I think in the context of perfections, obviously you can have consensual perfections, but I mean, if the company is already facing financial distress, it's very unlikely that that company will allow you to perfect consensually. Even then, there's still a risk that someone like SARS can come and challenge your consensual perfection. So I think the role of counsel, because in most instances, as I say, probably there's a liquidation set down in the next 2 weeks, so you need to perfect. The role of counsel, I think, obviously you'll have to draft the papers. But one of the most important things is you sort of have to then decide what form of proceedings are you going to launch these proceedings. That's, I think, your attorney will be looking for you for. Are you going to go ex parte? There's a bit of a risk with that, ex parte, because there's a heightened risk of disclosure. So that's something that you as counsel have to think about. You can go part A, part B. Part A, you'll sort of get the authority to attach, and then you can always get Part B in the normal course, which would then be the authority to sell. You can also do a ruling easy. That also has its own challenges, but I think that's where as counsel you can sort of add value in not only designing the papers, but also making those strategic decisions in imperfections. Thanks.
Thank you, Vincent. Lauren?
Yes, now I was just going to add to Nastasia's point is one of the other ways that counsel can get involved is where you go to court to set aside a vote as inappropriate after the business rescue plan has already been adopted. It doesn't mean that once a plan is adopted that somehow it's just smooth sailing from there. Sometimes it isn't. So, and then the other way in which counsel can sometimes get involved is where the business rescue is eventually terminated. And maybe that will actually lead into Karushka's section.
On how you terminate.
Yes.
But before we do that, I'd like to go, there was a question in the back. There was a question right in the back. Is your question? Apologies, but she did put up her hand first.
That's cool.
Thanks. We'll come to you next.
Hi everyone. So I've got 3 questions. Am I allowed to ask
3?
them?
Please go ahead. Please go ahead. There's nothing worse than silence if you're sitting in a panel, so we're happy to answer questions.
Help yourself,
So my
guys.
first question would be, what is the success rate of businesses going into business rescue proceedings after they've been placed in liquidation? And the follow-up to that would be, can we say that our courts are skilled to deal with this area of law compared to other jurisdictions, or could it be that there is a need for specialized courts? And the last one is, what is the main cause for failure of business rescue proceedings?
Okay, so those are 3 great questions, and I think that our council should perhaps take a stab at answering that. I see
I'll take the
vigorous
first
nodding there, Shamani. Go ahead.
No, I'll take the first one because I spoke about liquidation. So
Yes.
we are now at May. I've had 3 applications for business rescue while a liquidation order had been taken. And I mentioned earlier that it's very difficult to get a business rescue order after an order has been granted, either final or provisional. And so the success rate of the return of the company to radical, or the radical improvement to the company so that it trades profitably, is quite high because the test is so difficult to achieve. And so it is in instances where you've got government guarantees, where it is very clear that you just need to restructure and get the right people on board to save this company. And in that way, you would obviously be achieving the purposes of the New Companies Act, as Karusha has said, to save jobs and so on. But it's quite high because it's difficult to get that order, particularly once a company has already been placed in liquidation.
Okay, question number 2. Do we need specialized courts?
Okay, I'm going to answer
Karusha,
that question.
go ahead.
Is everybody able to hear me? Okay, great. Thanks. So in the Gauteng division, we have the specialized commercial court, and there is a long list of matters that that particular court deals with. One of them would be business rescue, and the other one is obviously liquidations. And considering the overlap between the both of them, I think it fits nicely. And in this division, certainly, it has been catered for that there is a specialized commercial court. Whether in terms of the practicality of having a specialized court that deals only with business rescue applications, I'm not sure if that is a possibility. But I do think that in the case of the specialized commercial court, certainly the judges that are allocated to deal with these matters are sufficiently experienced in this particular area of the law. So the question then goes to what happens in the other divisions. I think in a lot of the other divisions, for example, KwaZulu-Natal, there isn't such a specialized court. So perhaps what is now in the Gauteng division can then be implemented in the other divisions. It certainly would be very beneficial if that is the case. Business rescue is a specialized area of law, that is correct, but it is not impossible for the judges to get to grips with it. However, given the short space of time, particularly in the case of urgent applications, and the volume of work that judges have to bear in a week, for example, they may not always have the time to get to grips with the issues that are arising, particularly in the situation of an urgent application. So I do think that there is a need, and it is certainly something which should be dealt with by the Office of the Chief Justice and then be implemented in the other divisions.
Let us live in hope.
Sorry, I just want to go back to the topic of specialized courts. Having had experience in the US bankruptcy court, I have seen how efficient it is to run a specialized court. In the US, they also have Chapter 11 proceedings, which is essentially similar as business rescue proceedings. But what happens there is that a judge is allocated a restructuring matter. And every single application that concerns that particular company goes past that judge. So that judge becomes an intimate stakeholder and role player in that court, and it is such an efficient system. So is there a need for a specialized insolvency bankruptcy court? Absolutely. Is our commercial courts in our division coming to some assistance? They are, but not enough. Because if once you've seen how efficient a specialized court is, there is absolutely no doubt in my mind that we need one.
Look, I'm not sure how we can compare the US and SA given our relative resources and wealth. But I think, I'm encouraged to hear that we are working towards some kind of a specialized solution. I'm hoping that we'll get there.
We have young judges in the making, so.
And on the third question, if you'll forgive me, I think I'm going to take a crack at answering it. Why do business rescues fail? Certainly what I've seen is business rescues fail because there isn't an early enough intervention. There is not enough time to turn around the company, and there is not enough funding. What tends to happen is there's almost a paralysis. Nobody wants to do anything. It's such a difficult decision to make. And by the time a company goes into business rescue, there's often not very much that can be done. So I would say, I think the principal reason why business rescue fails is a lack of funding, a lack of a proper plan, and a lack of early intervention, because that is critical. Companies typically need time and money to turn themselves around, and often they don't have that.
I'll be very brief. So whether business rescue is successful or not depends on who you're asking. Because you remember the purpose of business rescue is twofold. So first you want to save the company and save jobs and all of those objects in the Companies Act. But the alternative to that is that you have to try and get a better dividend for the creditors. And so it is possible to enter into business rescue in order to get a better dividend for the creditors than the immediate liquidation. And in some instances, it would then be a successful business rescue if you achieve a better dividend for the creditors. For example, and I understand Vincent was the attorney here before I got involved, but we are involved in a matter in Evraz, which is a
Steel company.
Yes, which is a steel company that has been in business rescue for 13 years. The immediate question you ask yourself is, really? I mean, in my circle, if you're in ICU for 13 years, they switch off the machine, right? And you can't say you're resuscitating a company for 13 years. But the logic there is that the creditors will get a better dividend later on than they would have gotten at the time that you just had to make this decision whether you liquidate the company or you put it in business rescue. So the question on success really depends on who you ask.
Thank you for that
Yes, sorry,
answer.
can I just add very quickly? I think just leading on from Shimani's comment that the competency of business rescue practitioners is really an issue in our industry.
I think that is a whole discussion.
Yes, I know.
Several hours.
Going to leave it there.
But I believe there was more questions. But there was a gentleman before you.
Yes,
yes,
thank
go
you.
ahead.
My concern is about the difficulty of the practical effect of some of these provisions.
I'm so sorry. The mic doesn't seem to be on. I can barely
I was
hear
told
you.
it's on.
Oh, go ahead. Yeah.
I'm saying my concern is about the practicality of some of these provisions. For example, Shumani mentions the difficulties. I understand that, for example, Section 131.67, you can invoke it when there's proceedings instituted, and then you can intervene, as it were, and ask for them to be halted pending business rescue practitioners. Now, I, as a practitioner, I'm sitting with a client in Chambers. What type of evidence am I looking for to be able to overcome those insurmountable challenges? Especially considering that some creditors are not privy to certain information like financial records, the books of the company. What am I asking the client to give me before I go to court and accept a brief and get myself a nosebleed?
That is
and have you seen a success, for example, in terms of Section 131.67, where they had to overturn it? And what type of evidence? Is it a prima facie case you have to make? Is it a reasonable doubt? I don't know. So are these things very insurmountable, or are they just practically impossible?
Yeah. So it is very difficult because you don't have that sort of information that a director would have when they make that sort of decision. But the courts have said that you don't have to provide a detailed plan. That's not your job as an affected party. That's the job of a business rescue practitioner. So in instances where you as a creditor believe that you can have this company saved and it to enter business rescue, you more often than not have to prove that you have post-commencement finance that would get you over this hurdle. And once you have that, or you've got an idea of how you're going to get that, it becomes a bit easier to convince a judge that this company can be rescued. And usually you would not have the resources that the company has to go out and look for it. So you have to be a muscled creditor.
Like a bank.
Yes.
I think there's the answer.
Sorry, just to add to that. So we've had a matter where a company was not yet in any sort of liquidation, wasn't provisional or final, but it was facing 3 liquidation applications. And we
3
still
separate creditors.
yeah. And the fact of the matter is, once a company is so far gone, you will get the assistance of the board to rather place it into business rescue.
Yeah.
So you will get the necessary information. You just have to ask. If you are a creditor that wants to place a recalcitrant debtor into business rescue, then it's really showing to the court that it is financially distressed. You'll know because you're the creditor that's not being paid, right? So that's not a difficult hurdle to cross. The more difficult hurdle is going to be whether or not there's a reasonable prospect. And you as a creditor should also know whether or not your debtor has an underlying business that's worth saving. Because otherwise you would rather go for liquidation, right?
Yeah.
So you'd have a feeling for whether or not those 2 criteria that is necessary for successful application exists. So it seems daunting, but if you really drill down to it and you ask your client all the right questions, they probably have all the information at their fingertips in any event.
Okay, thank you for that. We've got time for one last question. Sorry, there's a lady in the back, but before you ask your question, I need to tell you that we have included a survey and a QR code, and if this is a topic you'd like to hear more about or any other topics, please do let us know, because the initiative is always looking for topics. So with that, please go ahead with your question.
Thank you. My daunting question coming in, I wanted to know, is it desirable to banks for the businesses to be rescued, or is it more desirable to a big creditor like a bank for liquidation rather? Which one do the banks is more desirable for the bank? But a follow-on question to that is that you just said the intervention. The reason why business rescue is not successful mostly is because the intervention is late. If it is desired, because the way I see it is that those provisions of the Act are there to basically boost our economy for businesses to stay alive, is it not then a value add that the bank can offer sort of as a fringe service to its clients to say, if you start seeing that you are going into trouble, let us know and we'll see, what can be done about it.
So, colleagues, if you don't mind, I'm going to take this one.
Yes, please, Deline, do take it.
That is an excellent question, and it's something that I think a lot of the public grapple with insofar as the bank's involvement in business rescue. But contrary to what the public might think, business rescue is first and foremost the priority of the bank. It is our absolute priority to save jobs. We are very interested in job losses, and the loss of businesses is not good for business. It's not good for bank business. We are interested in keeping businesses alive. And when I talk about intervention at an early stage, no company that is serious about rescuing their business will not speak to their bank first. Because the idea of being able to get out of your financial distress, if you see, for example, that you've got, as a company, a big debt that's coming up that you're not going to be able to pay, the sensible thing to do is to see your bank and get some kind of liquidity line, some kind of funding, so you are no longer financially distressed. Now, companies who, and I'm not going to say they aren't out there, because there are companies who like to abuse the process and simply file a business rescue resolution without contacting their bank. Now, that is already starting off on the wrong footing, because the bank has then been caught on the back foot. Potentially, we have not perfected our security. The business rescue practitioner wishes to use the proceeds of our security to fund the business. And in those circumstances, you are not going to find a bank bank that is going to be entirely supportive of that. You know, ultimately, whilst the banks, every bank in this country want to be good corporate citizens, and the amount of funding that banks do in every single business rescue that I've seen, particularly the big ones, I think that the public doesn't see all of that, how much commitment there is to saving jobs and upholding this economy. Although we do get a bad rap, I'll concede that. But where a company has not come and been forthright with the bank and we are caught off guard, that is, I think, a sign that this company is not really taking that business rescue and rehabilitation seriously. Yes.
Dedicated.
Yeah, that's true. So every single bank in South Africa has got dedicated people that work on what we call distress debt. Now, by the time a company goes into business rescue, I can guarantee you that most banks are already aware of it. We're already working in the background, trying to rehabilitate this business. And, you know, for those of you who came to the discussion regarding consortiums and informal workouts, you would know that there is a huge amount of work that is done outside of the judicial system in order to try and negotiate the best outcome for both creditors and employees. It's a big issue for us. And also knowing that banks are highly regulated. We've got conduct standards. We report to the SARB, the FISCA. You know, it is not in anybody's interest for banks to be reckless and simply put companies out of business, because who's going to be left? Who are we going to fund? Okay.
Evening,
So-
everyone. Oh, sorry, I thought you finished. Sorry about that. I have one last question.
Okay,
Can
go
I
ahead. Can't hear you too well.
Oh,
Oh,
okay.
there, that's perfect. Thank you.
My question is, evening, everyone. My question is, what are most important things that needs to be included in a business rescue plan? Thank you.
It's there.
I think the
I'm
attorneys
going
must
to
answer.
our panel. Yes, our attorneys.
So,
Provision there.
Section
150.
150
150, yeah.
really divides it into three parts. You have to deal with the background, the proposal, and then the conditions. So parts A, B, and
Yeah.
C. And really what needs to go into the plan is set out quite clearly in section 150. That being said, if I get a plan, I immediately jump to the proposals part, because that's the, you know, I know the background. Most creditors do. They've lived with this company long enough to understand why it's in business rescue. You want to understand what is going to be done to rescue the company, if not the company, at least the business, so that you can get a higher return for creditors. And I find that a lot of business rescue plans fall short on the proposal section. They have very general terms, and I understand why, because you have the Arkomanzi cases which said that you can't just go and amend the plan. So you don't want to be too specific in the plan either, but I think that is really the reason for business rescue is to formulate a proposal to rescue the company. And another thing that's found its way into business rescue plans that I would invite you to go to websites like the Saripa website, the TMA, is they incorporate ADR provisions now. And we had a bit of a debate about ADR provisions before we sat down and started speaking to you. So I don't know, Shimani, do you want to talk about the ADR provision?
No.
That's so much to say, and now you're climbing up. What?
Look, these provisions are a very difficult concept. Generally, I promote ADR, but I have formed a resistance, against ADR in business rescue, for the simple reason that you lose jurisprudence when issues are dealt with in ADR. But ADR provisions are generally included in business rescue plans, so that issues that arise out of the business rescue plan are resolved by means of ADR, with the assumption that ADR is quicker than than the court process. I know that AFSA has started an initiative where they deal with these sort of issues, and Nastasha was telling me that one of the issues that comes up is that the rules of AFSA are not aligned with what the terms are in the Business Rescue Plan and or the Act. So those issues are teething problems that you can resolve. But I mean, I think business rescue still has a long way to go with regards to jurisprudence, and it's probably better that the courts give us clarity on certain issues. But as regards to the business rescue plan, it's generally an agreement. You can deal with it by means of ADR.
Yeah, I think it's also just worth pointing this out. Because a business rescue practitioner cannot suspend the rights of the counterparty, right? If there is an ADR provision in the actual agreement between the affected person and the BRP, the fact that the plan, not the BRP, the company, the fact that the plan contains ADR provisions would not override the contractual ADR provisions vis-a-vis the company and the affected person, unless, of course, the affected person votes for the plan, thereby acceding to it, and then it's a variation, a written variation. So there's those things that's also relevant.
Thank you. So we have sadly run out of time, and thank you very much for a fantastic discussion. For anybody who hasn't had a chance to ask their questions, please find us over a glass of wine. But before we could conclude, I would like to go to Karusha just for one final closing remark.
Thank you, Deline. I think in closing, there's just two things I would like to say. So from a council's perspective, I think somebody raised the point, which was a query really. My suggestion is that there is, it would be beneficial for council that are not experienced in this particular area. It's not very difficult. It's a few short sections of the Companies Act. If you would feel more comfortable, there are many short 6-month courses that can be done through correspondence, through UNISA, for example. Take the time, go and familiarize yourself with it so that you are more comfortable and ready when you are called to do this kind of work. There's also a thesis, which it's not very long, it's I think 200 pages, by, guys, you read every day. So, if you want to represent Nedbank, you're going to have to know what you're talking about, because as you can hear, Deline knows her stuff very well, as do all the other legal advisors, as do the attorneys. So what value are you going to add to the matter? Yeah. So back to the thesis. It's actually a shortcut, really, because it's about 200 pages. It's by Dr. Pongula, who was at the University of KwaZulu-Natal, Pietermaritzburg, and who's now at the UCT Law School. Very friendly guy also. If anybody wants to contact him, I can gladly pass on the details. The other, if you really are interested, is a book on business rescue by Dr. Eric Levenstein, right? Which I found very, very helpful and very, very useful. It's the go-to book and the go-to text. There's also Henoksburg, but I find Dr. Levenstein's book is very much more easier to understand, particularly if you're not experienced in this area of the law. But even if you are, it's an excellent reference. For me, it is the primary and go-to source to deal with business rescue matters. So that's what I can suggest. The second thing that I would like to say is I would like to extend my thanks on behalf of the Female Council and the Duma Nokwe group where I'm from to Nedbank for this particular initiative. We always hear about the need for transformation. We always sit in a lot of rooms at a lot of events where discussions are held about why there needs to be transformation in the legal profession, particularly in the context of female counsel, bearing in mind that if we look at the ESG continuum and when companies like Nedbank, for example, would need to do the ESG reporting, we are second-tier suppliers as advocates. The reporting stops at the level of the first-tier suppliers, which are the attorneys, and there is this disconnect between the two. So it is quite a big step for us to be situated in this room today. especially considering that it is from Nedbank, the client itself, that is driving this initiative to say that we would like to meet the female council that would like to do this work or that are doing this work that we can brief. When we talk about transformation, it comes down to one thing and one thing only. It is economic transformation. It is allowing women to participate in the economy. How do you sustain your practice? It is only if you have a constant supply of work to be able to do that. And the biggest challenge that women face is having access to this kind of work. Nobody was born knowing business rescue. Everybody learned it, right? And it's something that everybody here can do. It is not above anybody to be able to learn if we just apply it. So go and read the thesis. It's the starting point. But thank you very much. And I think also in the context of the CEO's pledge, which I really liked when I read about it, I feel Nedbank is one of the signatories to the CEO's pledge, and it talks about equal economic participation and equal economic opportunities. And for me, it is a tangible solution to give effect to the CEO's pledge, because often people sign memorandums, they sign pledges, they sign a whole host of things. As I said, everybody supports transformation, but this is something which is sustainable and something which is a cogent solution to a problem that we all know has existed for many, many, many centuries. So, thank you.
Thank you, everybody. Just one final correction on my point is that it's not only Nedbank. I have to really give credit to Tracy and Tumi and the ENS team that helped us get this off the ground. So thank you very much, ENS. We cannot forget about you in this. And that then concludes the session. Thank you, everybody, for your participation.